when the court is ready, if you'll allow me to just read down the record so that my client can hear it and know that it's exactly what she discussed with us last week, and I think we can move forward fairly quickly.
Well, we were actually scheduled for the issues as it relates to Mr. Annayia first, but I understand, Ms. Underwood, you may have some, you may need some room, if you will, on that one, but I look forward to any comments you have on the bench conference and how you would like to proceed.
With respect to mother only, Judge, or?
With respect to your client.
Your Honor, at this point, I believe my client and I are in agreement with also accepting or taking a plea today on this file, as there was already the trial had already began, and it's to a point where we think it may be in Bobby's best interest to continue moving forward and ensuring his best interests are met. With respect to,
if you wouldn't mind coming up to our microphone, I can hear you.
With respect to the respondent mother, we're just hopeful again that the parties can continue to work together to facilitate parenting time and ensure that the child's needs are met. But again, at this point in time, that's really at this point all I have to add to anything. Thanks.
Okay. Ms. Heiss?
I don't think I have anything to add about the bench conference. Thank you.
All right, well, at this point, I have a request essentially to allow the plea of both parents in this case. Do you find that to be in the best interest of the children?
Yes, Your Honor. Very well.
Okay, so Mr. Annayia, if you could come on up and have a seat by one of our microphones, or even, you know, if you want to stay at the podium for a few minutes, whatever you're doing. And then Deputy Ames, if you could swear in Ms. Tiffany before, as well as Mr. Roberto Annayia. Mr. Annayia.
Please raise your right hand, sir. Do you both swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. All right, Ms. Hennigan, let's start with your client. If you don't mind, I know we have the court's been provided a written plea agreement with the terms.
Yes, Your Honor. Tiffany, can you hear me okay?
Ms. Kapoor, we're getting a lot of additional noise coming from your signal. Is there a quieter place that you can find?
I'm sorry, Bob. Yes. Let me. Is that better?
Judge, I would just ask you, if there's the minor child is present, I would ask that he not be anywhere near where she's at this point to be able to hear what's going on.
Is that possible, Ms. Kapoor?
Not exactly. Not at the moment. Yeah. Here. Yeah. Yes, I can do that. Give me about 1 minute. Mommy, be right back, okay, sweet boy? Okay.
Go ahead, Ms. Hennigan.
Thank you. Good morning, Tiffany.
Good morning.
I just want to read the plea agreement to you just so that you're aware that what you're agreeing to this morning is what we talked about in our meeting last week, because it kind of just got over to us this morning, so I know you may not have a copy in front of you, okay?
Yes.
Okay, and then I also want to ask you to sit down somewhere and be really still, because when we all see you moving around.
I'm trying to move away from the baby. Yes, he's having a difficult morning.
Got you. Okay, so
that's why he's home. He's having some difficulties. So
got you. So maybe if you can just be still just for a couple minutes, we'll get through this really fast, and then you can put all your attention on him. Okay. Great. So we talked about when we met last week, we talked about amending specifically 4 of the items that were in the original petition. And one of those was number 7. where it talks about physical abuse, improper care, and unfit home environment, and you wanted to make sure that it indicated that you had made attempts to get help. Remember that?
Yes, I do.
Okay, so it now reads, as it relates to Tiffany Pecor, while she did make efforts to report issues, she's not provided proper care to Roberto Annayia IV by exposing him to violence in the home. And as to Malik Nasher, she has engaged in physical violence with him. And because of the subsequent no contact order, does not have a fit home environment for him to reside in.
Correct.
Understood? Okay. As to number 8H, that was the one that talked about the domestic violence charge. And that has now been amended to read, Tiffany admitted to the assault with Malik and has pled to disorderly conduct.
That is correct.
Okay, thank you. Next was as to number 12, active efforts to prevent removal. That was the one that talked about the parental rights, and you told us there was a correction because it initially said your parental rights to 5 children had been terminated, and we did confirm that that was incorrect. So it now reads, Tiffany has extensive past CPS history, which includes termination of parental rights to 2 children. Throughout the previous cases and this one, the family has been offered many services.
Correct.
Thank you. And the last one that was amended, number 13, for your CPS history, it simply states now that Ms. Papor's history with CPS includes 5 confirmed CPS investigations. Okay. With those amendments done, Tiffany, are you prepared to enter into a plea agreement so that the agency can take jurisdiction and you and your family can begin services?
Yes, I do.
Thank you, Your Honor.
Ms. Hennigan, your client has the right to have all of the allegations read onto the record. Have you spoken with her? Do you know if she wishes to waive the right to have the remaining allegations read?
We did waive that right in the last hearing, Your Honor, and she's fully aware of all of the allegations.
All right, Ms. Before, if I accept your plea, you are giving up the right to a trial by judge or trial by jury, the right to have the petitioner approve the allegations in the petition by a preponderance of the evidence, the right to have witnesses against you appear and testify under oath at trial, the right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I've just indicated to you if you admit the allegations in the petition and the plea agreement as they were outlined on the record today?
Discussion then shifts toward potential consequences. The judge outlines possibilities ranging from services and supervision to more severe outcomes if conditions fail to improve.
Yes.
Thank you. With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. With regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea?
I do.
Thank you. Do you have any questions about any of the information I've given you so far?
No, I do not.
All right, very good. Mr. Annayia, I know you've been sitting at the table. I'd like to back up for just a few minutes. Ms. Underwood, what are the terms, if any, of any plea agreement that's been reached with regard to your client's wish to enter a plea?
He will accept numbers 1 through 4. And then for number 15, which begins his allegations, we would just like to say, or to remove that he hasn't provided financial support because he has continued to pay child support throughout this case. So we would just like number 15 to be amended to reflect that.
Okay, objections?
I understand he's behind in that financial support, so I wonder if we couldn't say has not provided full financial support as required. I believe he's the one that testified that he's behind in support.
Are you regularly paying support?
I do, I mean, I might be a month late to pay. I'm behind $1,000 on 3 children.
Okay, Mr. Annayia, I think the proposal is simply to just note that, what was your request, Ms. Heiss, regular support?
Yes,
So it would read, during this time, revert to Annayia the third has not provided regularly any physical, emotional, or financial support.
That's acceptable, Judge.
All right. Ms. Constantino?
I would have no objection.
Ms. Thomas?
No objection.
Any position, Ms. Hennigan?
We have no objection, Your Honor.
Very good. So then the allegations would be, that I would be considering would be 1 through 4, and then 15. Are there any others?
Let's see. He doesn't, 17 is accurate, and so is 18, Judge.
Right. Okay, if I could have confirmation from our other attorneys, if that would be sufficient for purposes of review for the factual basis of the plea, assuming we're gonna get some testimony on that as well, but just initially, Ms. Thomas.
I believe it is sufficient.
Ms. Constantino,
I believe it's sufficient as well.
any position, Ms. Hennigan?
None, Your Honor.
Ms. Heiss?
I believe it's sufficient.
All right, very good. Okay, Mr. Annayia, if I accept your plea on the terms that we've just heard, you would also be giving up your right to trial by judge or jury, your right to have the petitioner prove the allegations in the petition by a preponderance of the evidence, right, the right to have witnesses appear and testify against you under oath at trial, or any that you feel could be subpoenaed to testify on your behalf, the right to cross-examine witnesses, and the right to, well, here we are, the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand to be giving up or waiving those rights if I accept your plea?
I do.
With regard to the consequences of your plea, or in other words, what will happen, the court would do the same as it would for Ms. Vapor. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or relatives or in foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment assessments, and parenting classes. If it appears that you would not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea?
I do.
Do you have any questions about any of the information I've given you so far?
No.
Very good. Is anyone making you admit to the petition?
No.
Ms. Vapor, is anyone forcing you to or making you admit to the allegations of the petition as outlined in your plea agreement?
No, Your Honor.
Has anyone threatened you in order to get you to enter the plea, Ms. Vapor?
No, Your Honor.
Mr. Annayia?
No.
All right, outside the terms of the plea agreement, has anyone promised you anything in order to get you to enter a plea, Ms. Vapor?
No.
Mr. Annayia?
No.
Are either of you under the influence of drugs, alcohol, or any other mental or physical condition that could get in the way of you understanding what you're doing right now? Ms. Vapor?
No, Your Honor.
Mr. Annayia?
No, Your Honor.
Very good. Would you say that your decision to enter a plea under the terms of your plea agreements, of course, is a decision that you've made of your own free will, Ms. Vapor?
Yes.
Mr. Annayia?
Yes, Your Honor.
All right, very good. As to the factual basis of the plea, Ms. Thomas?
Your Honor, I believe because both parents are admitting to the allegation, that they can be questioned, and I would read that to their attorneys.
All right, so essentially, I would be looking at the allegations that were outlined in the plea agreement and accepting those as correct. Is that what you're saying?
Yes, Your Honor.
Any objection to that, Ms. Constantino?
No objection, Your Honor.
No objection.
No objection, Your Honor.
Your Honor, I would ask you to consider that piece plus the testimony that we've already had, all of that together to accept the plea.
Any objection to that, Ms. Underwood?
No objection.
Okay, all right. Well, one more time, could you all confirm that you're satisfied with the advice of rights and the factual basis of the plea?
I am.
Yes, Your Honor.
Yes, Your Honor.
Ms. Hennig?
Yes, Your Honor.
Yes, I am.
Very well, thank you so much. All right, I do find that the plea as given by both parents is knowingly, understandably, and voluntarily made. And further find the record supports that one or more of the statutory grounds alleged in the petition are true. That is specifically as it, in short, as it relates to Ms. Before, with that domestic violence in the home between her and the older child, which of course the younger child was present for. And those dynamics certainly pose a risk of his physical and mental health within the confines of the home with his mother. As it relates to the father, I do see that there has been an extended absence of this parent in the life of the younger child, which would certainly constitute a violation of the statute under the jurisdictional sections that the court has been asked to consider, specifically failure to provide that safe environment and failure to provide proper care and custody.
The judge explains that a case service plan will become the roadmap used to measure progress. Compliance will determine whether the family moves closer to reunification and stability.
The next stage of our proceedings is referred to as our initial disposition. As I understand it, Ms. Before may wish to have that hearing conducted today. You would normally otherwise, Ms. Before, have 28 days to meet with the department to discuss the case services plan that will potentially become part of the court's order and will measure your progress as it relates to the issues that were identified today that need to be remedied in your household. Do you wish to enter into that case services plan today? If so, that will waive your 28 days to review that document, Ms. Before.
No, I don't know. I would have to talk to my attorney about that and see. I'm not really sure.
All right, very good. Ms. Underwood, I know this was a bit of a surprise to you and your client today. Would you like a few minutes as well to talk about this with him as an option?
Yes, Judge, I think that we still need to talk to the department and figure out what will be a part of that case service plan before we enter it into an order.
Very good. I do have the original date set of November 2nd for purposes of trial. That is a few days outside of our typical 28-day time frame to do the initial disposition.
Your Honor, may I ask that we also were on the docket at 11 o'clock. I wonder if we couldn't use this time. I know Mr. Annayia has asked to not have to travel. It's interruptive to his work, and if we could work a little bit longer this morning to try and get those done, if we could have that time.
Would you like to try that, Ms. Underwood?
Sure.
Okay, all right. And if it doesn't work out, then you know what the calendar, what the docket looks like. And if we need to try to squeeze it in somewhere else, then I'm happy to find some time within that 28-day time frame. But for now, I'll grant that request for a brief adjournment to allow the parties to navigate that question. Assuming there's no objection from Ms. Titus and Ms. Constantino.
No objection.
No objection.
Very well. Okay, at this time then I'll put everyone in the waiting room so that Ms. Before can talk with Ms. Hennigan, and then we'll send everyone else out for purposes of navigating the negotiations on Mr. Annayia's case.
Your Honor, I just would ask if my client would put on the record if I have permission to sign the plea agreement on her behalf.
Ms. Before?
Hey.
Morning, Ms. McVeigh. You are the ongoing CPS worker, correct?
Yes.
And you prepared a court report for today's hearing?
Yes, I did.
And attached to that court report are, you have your cover sheet, so thank you for that. There's the case service plan, drug screens, parent area report, visitation report, and a therapeutic visitation report. Are there any other updates or modifications that need to be made to your court report or any of the attachments?
The only recent update is she did participate in another therapeutic supervised visit yesterday in the afternoon. I don't have that report back yet, but she did get another visit in.
And currently the goal is reunification, correct?
Correct.
And what would be the barriers, I guess, this is in home jurisdictions, what are the barriers to being able to terminate this case and allowing Ms. Malloy to parent freely without court oversight?
I think the concern is, although she does have a lot of positives with following through with her CMH services, I have some concerns that she's not yet in therapy to address her mental health. And she did just start the supervised parenting time. Renee Moore had some concerns about can this mom parent alone? And the best way to do that, in Renee's opinion, was outside of the home, just Ashley and Jackson, and doing those observations. So that just started. So I'd like to see some more of those to see how she does.
Currently, the supervised therapeutic parenting time with Ms. Moore, how often is that scheduled for?
Right now, it's once a week for an hour.
And is there any estimate, or has Ms. Moore indicated to you about how long that would need to continue before there's an opinion about whether supervised parenting time needs to continue?
I don't have an estimate on that because it just started. Like, we've only had 2 of them. So I haven't asked her how long because it's still brand new.
You comment, so to Ms. Malloy's compliance with and benefit from her case service plan, you mentioned that she's in compliance in the majority part, I suppose.
Yes.
What are some outstanding areas that need to be addressed other than the supervised parenting time and counseling?
That's basically the only 2 things she's not doing right now. And I would agree with Ms. Heiss on getting Jackson into some school program. And also Jackson was qualified for speech therapy through Total Rehab, and that hasn't been followed through on yet. And I'd like to see that completed. I know Ms. Malloy was going to make an appointment. I don't have the appointment date yet, though.
And is Ms. Malloy on a wait list for CMH counseling services?
Yes, she is.
Can you just highlight for the record why it is important for Ms. Malloy to be engaged in therapy?
Because the reason this case was open was because of a mental health break where she was threatening to harm herself and doing self-harming behaviors in front of the children, and there was a whole domestic violence incident between them due to this mental health incident. So that's the whole reason the case is open. So to rectify the concerns of why the case is open, that's why it's important.
There may be an argument made, well, she is complying with all CMH services, she's taking her medication. Isn't that enough?
In my opinion, I think that we should go off the recommendations of Renee Moore, which is therapy and the supervised visits, to make sure that she's doesn't have another incident. And she did have some, she was very honest with me about having some concerns of paranoia and issues. And she actually contacted her doctor and got that taken care of without a hospitalization stay. So she is utilizing the CMH services.
I was just rechecking the case service plan. There is no requirement for a psychological evaluation.
The mother takes the stand and directly addresses several concerns. She explains upcoming appointments, ongoing efforts to secure counseling, and the family's attempts to help with potty training.
Evaluation, correct?
Correct.
As relates to the child and yes, moving forward in getting some structure in his life, are there community resources or through this intermediate school district, any resources that can assist this family in assessments, enrollment in programs or the like?
Yes, she did start the paperwork for Great Start for Jackson, but didn't follow through with that.
Is that something that perhaps maybe Ms. Edwards could assist with?
Yes,
Like,
but they're not willing to send him at this point. They don't want to, they want him to stay at home with grandma, so.
Okay. Is there anything else that you would like to bring to the court's attention?
No.
So I'm just gonna review. To the best of your knowledge, do you know if Mr. Kotke has tried to establish any custody order?
No, he is not.
Is that something that these parents are interested in?
They're together, so that's why there's not. I mean, they reside together, they're a couple, so not as far as I know.
Okay, thank you. Yeah, I have no further questions of this witness and would move to admit the court report and its attachments.
No objection.
No objection.
Thank you, they are admitted. Questions?
Can I inquire if the court were on YouTube?
Sorry?
Can I inquire of the court if we are on YouTube?
Yeah.
If we could maybe just refrain from using the child's name while we're on YouTube. Can you refresh my memory? How old is this child?
5.
Okay. And how would you propose that we go about toilet training this child who has some disabilities?
He doesn't have any disabilities.
Okay. So at this point, is it just a parenting course mom needs, or what is your proposal on that?
I know she's been working with Pauline Edwards on potty training. I think the importance is following through with being consistent, and it's a parenting choice at this point. I mean, I don't know of any disabilities unless we do possibly need an evaluation see if this is part of a developmental delay.
You're not asking for that at this time, am I correct?
Not at this time.
Okay. What do you envision the therapy to look like for mother? I know we want to get her in therapy. It's on the case service plan. What do you envision that to look like so she knows?
Once a week for weekly counseling.
And do you have a place where she might solicit that?
She is on the waiting list at CMH.
So she's already signed up for that.
Correct.
So
She did that several weeks ago.
okay, so she's not deficient there. She's just waiting for them to see her. Would that be accurate?
Yes.
Okay, thank you. Okay. Then it sounds as though we're envisioning Renee Moore's supervised parenting time, if it's successful, developing into unsupervised parenting time. That's the goal, correct?
Yes.
And it sounds as though you told us we don't know what our recommendation is going to be until we progress with more supervised visitations, correct?
Yes.
Are there reports generated from these visitations?
There's one attached to the.
Well, let me repeat. Will there be a visitation for every visit, or?
Yes. There's a report for every visit.
And will my client get feedback pretty soon after the visit?
She does, and she also is assigned homework assignments during these visits.
And I was looking at her paycheck stubs for her food delivery, and it seems as though that's a fairly consistent, good income. Would you agree with that?
Yeah, I don't have a problem with her.
No problem with that. Okay. So what would you say Ashley's strengths are?
That she is participating in her CMH services, and like I said earlier, that she is advocating for herself. So when she feels that her mental health is starting to deteriorate, she reaches out to her supports at CMH to avoid a hospital stay or to avoid, another incident in front of Jackson. She has a lot of strength. All of her drug screens have been positive for her mental health medications and negative for everything with the exception of small amounts of THC, which has been safety planned in the home. So that's not an issue. That's not a safety issue for Jackson. With the child. And she does have a lot of strengths.
And it sounds so the guardian ad litem's concerns regarding therapy, that's already been addressed by her. She's just on a waiting list, correct?
I believe she might be able to get in very soon. The last I talked to her case manager, she was like the top of the list. So she should be getting in within the next couple of weeks.
Well, it looks like potty training is really the only thing that we have that's a major concern today. I don't even know if that's a major concern, just a concern. Would you agree with that?
That and the speech therapy is a concern.
Speech therapy, that wasn't addressed. What do you mean about the speech?
Jackson has been evaluated by Total Rehab, and he qualifies for services through their agencies, and that hasn't been followed through on.
So what does Ashley need to do, and what assistance can she get from you to get on track with the speech therapy?
She's already, we talked about it a couple of weeks ago, and she's already made an appointment as far as I know.
So she's on track there, if we confirm that she has an appointment, correct?
Right, and I mean, just the concern is it was recommended during the last reporting period, and it still hasn't been completed. It could have possibly been completed by now.
Understand, nothing further.
Here's where the broader picture emerges. Officials emphasize that the family's strongest asset is its support network. Multiple generations are helping maintain stability.
There was a note somewhere in your court report that mother was thinking that the case might close at this hearing. Did you remember that entry?
I don't believe. We talked about what needs to happen for this to close.
And you're not recommending closing at this time?
Not at this time.
If she did all the things that you're talking about, she was doing counseling once a week, JK went to speech therapy and it's got into a program, probably not even by the next review period would be sufficient progress. Can you estimate that?
I would say that she could get it done within a month or so if she got on board and was consistent and followed through with everything on a regular basis, then yeah, I could see it closing sooner than the next reporting period.
Okay, so the housing belongs to JK's grandmother, is that true?
That's as far as I know, yes.
And the parents do not have a lease agreement on that home, is that true?
Yes.
And the income that you've been provided shows bank deposits from DoorDash, is that correct?
Yes.
Okay, so have you seen any other evidence of income besides those deposits?
No.
And are those both parents' deposits or one parent's?
They do it together.
Thank you. I have nothing further.
I have no redirect, Your Honor.
Okay.
Just one question, Your Honor.
Go ahead.
What's your opinion on accelerated review?
I don't have a problem with an accelerated review. The only reason I didn't ask for one is because the problem is getting things going and being consistent. And I mean, either way is fine with me. I'd like to see her get these appointments done because she is, like I said, has a lot of strengths and is doing well in a lot of areas, but we got to get these last few things done in order for us to make sure that JK is safe.
Thank you, nothing further.
Thank you for your testimony. You may return to any other witnesses?
No, Your Honor.
Call Ashley, please. Ashley Malloy.
Ms. Malloy, can you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ashley, can you tell us when is the speech therapy appointment for your child?
Friday.
Okay. And you heard what the expectations are regarding you and Ms. Renee Moore as far as expanding into unsupervised, correct?
Right.
Okay. And
I'm on the top of the list. I think they called me the other day and left a message. I was working and I called them back before court and they're going to call me back about the counseling. I think I am like really, really close there.
Great, okay. Yeah, apparently there is a concern, doesn't appear to be major, but regarding toilet training for your child. Do you need any assistance on that or what are your thoughts?
I mean, we're working with them. That's all we can keep doing. We try to give them prizes, try to give them, you know, different things to do. And it's just like something he's just taking a little longer to catch on to.
Okay.
I mean, he was a preemie, so I know they said sometimes that can affect it. So I'm not sure, but I know we do work with him. We watch Elmo's potty time. He has different snacks, different prizes he can get if he goes on the potty. So there's different incentives for him.
Good, okay. Are there any areas that you need help on that we can assist you with?
No.
Okay. Is there anything else you think that we need to cover or explore today?
No.
Okay. You've had a chance to read the report, right?
Yes.
Okay, thank you. I have no further questions. We'll see if the other attorneys have questions.
Questions?
No, Your Honor.
No questions.
All right, thank you for your testimony. Anyone else you'd like us to hear from today?
No,
Mr.
thank you.
McFarland? Ms. Hicks?
No witnesses.
Comments?
Thank you, Your Honor. I think that Ms. Malloy is making progress in her case service plan as reflected by Ms. McVeigh's testimony and the court report. As Ms. McVeigh noted, the outstanding concern is ensuring that Ms. Malloy is stable enough and receiving enough support from therapy and her natural supports to mitigate the risk of another mental health episode in which there could be a danger to the child again. I think that therapy is a very important component to that. The lack of follow through may also be stemming from high anxiety or things of that nature that we just don't have enough information on at this point in time. So you just request that the 90-day review take place. And I know that there is a mention of accelerated review, but that 90-day review will allow the department to continue to work with Ms. Malloy so that she has ample opportunity to engage in therapeutic services, work with the service providers regarding the child's needs, and get some stabilization with, or some normalcy, I guess, in routine with him as well. With that, we just.
The guardian ad litem stresses that certain concerns normally present in similar cases are receiving less attention because mental health stabilization remains the primary priority.
Also ask for, I guess, the discretion at this point in time for the ability to move to unsupervised upon Renee's recommendation, if that's appropriate. Thank you.
Mr. McFarland?
I'm glad some of the concerns of the guardian ad litem were addressed and that Ashley assigned the child for speech therapy. We've heard the steps that she's actively taking for potty training. That she herself is appears so is on the top of the list for her own therapy. So I'm progressing nicely, a good income. I think we are on a fast and the proper track. I know my client would like an accelerated review, so I'm asking for that.
Your Honor, what isn't being said here, I think, is that there is less pressure on this family for a legal income and independent housing because they are being encouraged to act as a multi-generational family. And so these things that we're asking for progress on are important. The other piece, we're not jamming them with everything. I'm not thrilled with this income. It's DoorDash, 2 people depositing. I need to see that they're paying their income taxes, that they're paying their other pieces that go along with having income. Because theoretically, I don't want them to be jammed up financially. It doesn't help this child in any sense, or if they had to go to jail for not paying their taxes. So we're not pressuring them on legal income. I think it's important to say that we're not pressuring them on housing. They have a functional situation right now, but we are 8 months into this case and we're getting things started. I think it's important to say that CMH is #1, and this mother participating in doing what she can do, taking her medicine, is such a big, important thing that we aren't even looking at some of the other elements that we traditionally look at. But, you know, we could say, we are 1 car repair away from not having that income, and we need to have savings and we need to budget for that. We're leaving some of those things alone and allowing the grandmother to be considered as part of their stability because the CMH is so important. But these other pieces, you know, Jackson's at home and he gets outside some in the backyard, but we need him to socialize with other children. And he had some relatives come recently. They were looking forward, you know, this is a really great, strong family. Anyway, so it's a balance. Legal income. It's legally coming in, but there are pieces that need to happen, but I'm not gonna harp on it. I just wanna point out that some of the things that I traditionally would do, are outweighed by the CMH participation and letting Pauline in the house and participating with her and being honest. So many strengths in this family. So that concludes my comments.
Well, the court finds all interested parties were given notice for purposes of today's review hearing. I do find progress is being made towards the goal of reunification. The child is with the parents in the home. So perhaps the better way to describe this particular situation is to maintain and obtain an environment that is continues to be safe for the child. The risks that brought the child under the jurisdiction of the court were clearly articulated by Ms. McVeigh today. Her efforts are certainly in satisfaction of her obligations. Thank you. As well as Ms. Heiss.
Thank you.
There are some important goals that need to be met by this family before the court can release jurisdiction, and that is seeing that the child is meeting his goals, is getting potty trained, is getting through his speech therapy, some of those things that we can look and say, objectively speaking, that his needs are being met, and this is a child-centered home. I read through the exhibits and noticed that he has been discharged from his speech therapist because of the number of canceled visits. So that's an issue because that is an indicator that perhaps there are still some things happening at the home that could be related to the mental health of Ms. Malloy that are getting in the way of him being able to get his needs met. He needs to be in a structured environment. And if you do that, he needs to get potty trained. So continuing to work with the parent aid services and to gain those skills necessary to help him obtain those goals that he needs to meet for his own developmental progress is, again, an objective, important indicator that this family needs to demonstrate for the court to relieve them of the jurisdictional supervision that's currently in place. So for those reasons, the child will remain under the care and supervision of the department in the next reporting period, placed with his parents. That is the safest and least restrictive under the circumstances. I do want to say I appreciate Ms. Malloy making sure she is engaging with her CMH caseworker and taking her medications and dialing that in. So that's great progress. And so we'll continue to look for you to work hard on those goals and show us some of those other pieces of progress between now and when we come back. We'll have our next review hearing, which will also be a permanency planning hearing on October 24th at 2:30 p.m. Again, that's October 24th at 2:30 p.m.
And parenting support remain unfinished. The family leaves with encouragement, but also a clear warning that continued effort is required.
Your Honor, they're reviewing my file. I still am not sure that we have Malik served with notice of these hearings or proceedings. I will allow Ms. Heiss to give further detail on that, but that is one of my main concerns on this matter, is proper service and notice to mom.
Probably Ms. Holmes is who you are looking for, or did you mean me? You said Ms. Heiss for the service issue.
Nope, I'm sorry, Ms. Heiss, I just meant for the other
oh, yes.
issues that we discussed.
All right, any other comments about the sidebar, gentlemen?
Oh, yeah.
I think we should dismiss this case against Mr. Johnson. There's nothing here.
Comments, Ms. Heiss?
No comments further, thank you.
All right, very good. Well, I think we're gonna need some witness testimony from Ms. Holmes. Regardless, Deputy Angel, do swear please Ms. Caitlin Holmes.
Ms. Holmes, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
One moment. Looks like we have had, I believe this is Mr. Johnson. Yes, I thought so. So he's having some trouble connecting to audio, but he has joined us by Zoom. All right, so Ms. Thomas, as you address your questions with Ms. Holmes, I would like to know if there are any affidavit of parentage forms. I did not receive any, even though I ordered DHHS to supply those and to advise on the status of paternity investigation, as well as an update on the home investigation of the father's home for possible placement, the FTM, basically the things that were ordered at our last hearing. I'd like some updates on those as you explore your other issues, please.
Thank you, Judge. Ms. Holmes, as it relates to the children, where are they currently located?
They're currently in the care of their father, Stephen Johnson.
And do you know if a DH-9 was provided?
She's sworn in.
Yes.
I'm sorry. She was. I wasn't paying attention.
I'm sorry. Could you repeat that?
I did not finish my question. As far as the DH-69 indicating that there was a move to the children, do you know if that was filed? I'm not sure that you'd be the appropriate person to ask, but are you aware of that?
Yes, it was filed.
Okay, and was that sent out to the parties? I don't believe that my records have it, nor the LJLs.
I believe.
So do I.
Ms. Burry, she sent it to the court, and I'm not sure if it was distributed. I did send it to Ms. Heiss recently, as she requested it.
Okay, thank you for that. And given that the children are with Mr. Johnson, is it your opinion that there's no longer a imminent and substantial risk of harm to them?
Yes.
And as it relates to the children's AOP numbers, do you have those?
I do not at this time. We have not received them.
Okay, and when were those requested from the state?
I do not have the date off the top of my head. I would have to double check with the my supervisor.
And have you had any contact with?
Attention shifts toward prevention rather than punishment. The judge stresses that participation in services could help avoid future child welfare involvement.
Ms. Rembert.
Yes, on August 1st, she reached out to me from a phone number that does not belong to her, and she stated that the phone number that she reached out to would not be a good number to contact her at. And I was able to inform her of today's trial, as well as I received an email address from her so I could send her the petition as well as the removal order. I have not had contact with her since then.
And did you file a proof of service indicating that you had provided the information to her?
I have not.
Okay.
Oh, the record should reflect Mr. Johnson's dropped out of the meeting, but he did connect audio and I know was present for most of Ms. Holmes' testimony so far.
Okay. Ms. Holmes, is there any reason to continue this petition at this time?
At this time, we have not had contact with Ms. Rembert, and we would like to continue attempting to get contact with Ms. Rembert in order to ensure the safety of her children when it comes to her.
Okay, thank you. Your Honor, I have no further questions of Ms. Holmes.
Ms. Holmes, do you know when those CHS 69s would have been filed? I checked with my clerk's office this morning specifically to make sure I had anything that was supplied in anticipation of today's hearing. And they informed me they did not have anything.
I'm not certain of the exact date. Ms. Berry might have she might know the exact date as she was the one who filed them.
Thank you. Questions of Ms. Holmes, Mr. Brooks?
None.
Mr. McFarland?
We didn't do a publication for my client, correct, Ms. Rembert?
I'm sorry, could you clarify what you said?
We did not do a service by publication for my client, correct?
Yes.
Nothing further.
Ms. Heiss?
Have you, Ms. Holmes, been to the home where the children live?
Yes,
And that's in Hudson, Michigan?
yes.
Thank you, nothing further.
Any redirect?
No, Judge, thank you.
Any other witnesses?
If Ms. Berry could be sworn in just to confirm the filing of that DH-69, please.
Here, do I have names? Ms. Elizabeth Burry, please.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Berry, can you just give us a brief recap of when you filed that DH-69 indicating the children were moved?
It was filed on August 10th.
And did you file a proof of service noting that you had also provided it to the parties?
No, I did not.
And just for our record keeping, what email address did you file that DH-69 with?
I sent it to Celeste Floors. It was the same person that I originally got. We got the court orders from saying that the children could be returned home to Mr. Johnson, and she told me to send the 69s over to her. But I did not have any of the other contact information to send it over, so that's why it was just sent to that email address.
Okay. Thank you. Your Honor, I have no further questions of Ms. Burry, and on that point, it does look like my file has it. I don't believe my secretary would have intended on filing that for the department. Typically, that is something that our workers do. So I do have that, and if that was my responsibility, I do apologize for not forwarding that to the other parties in this matter so that we knew the update on the children. I still don't, I think my problem still lies in the fact that I don't have a proof of service for mom, formally indicating that she was served. We have children with a parent who is deemed safe and appropriate. There no longer seems to be an imminent or substantial risk of harm to them. I guess I have some concerns about parentage, but with the children in Mr. Johnson's care, I believe that he has the ability to file for custody, and we would hope that he would do so in order to appropriately safeguard them.
Any witnesses or argument, gentlemen?
Now, I have one question I'd like to ask this worker.
Oh, by the way, your client has rejoined us.
Okay. Ma'am, Ms. Burry. I find her on the screen.
She's in the bottom left.
Yes. Before bringing this case to Lenawee, did you guys try to file this in Washington County?
I believe that would be a question for Ms. Holmes. I'm not sure if we tried to file in Washtenaw or not. We did not try to file in Washtenaw.
Thank you. That's all.
Just comment when it's done.
Mr. Brooks, did you want to hear from your client, or do you have any comments today?
I think he'll be fine with what is about to happen.
Comments then, Mr. McCrum?
I would agree with Mr. Brooks. Kids are safe. Returned to a parent. I think this case should be closed. My client has not been properly served, Your Honor. I don't know how much more time this case dragged on for multiple months with my client not being served.
Ms. Heiss.
Thank you, Your Honor. August 18th, I realized I contacted the foster care home and they didn't have the children. So when DHS 69s are filed, when they are distributed, it helps me to avoid that error so that we all can show our professionalism and not look like we don't know what each other are doing. But on the 18th, I emailed to Caitlin and she was on vacation. She got right back to me, got me some of the information, and then on August 23rd, got me the a copy of the DHS 69. So I was able to reach out to Mr. Johnson who lives here in Lenawee County. He offered me a visit the other morning, but I had a new abuse and neglect come in, and so we rescheduled for last night. I have seen the children face to face. Their home is clean. It has, the children are clean. The children are, all three children appear to be very well cared for. If there's anything wrong with their environment, it would require a lot of investigation, because what I saw were healthy children, a father who is interested and plugged in their care. He is motivated to take care of them all and to protect them from their mother. And in my estimation of the situation, he shouldn't be a respondent. Mother may need to be a respondent, but we at least have to find her and serve her and have a hearing on the allegations. So I don't oppose dismissing the case. Thank you.
The court finds all interested parties were given notice, with the exception of Ms. Rembert. She may have had notice, but we don't have proof of service indicating that she was served by email. I think it's safe to say she did have information about this, at least as a courtesy from Ms. Holmes during her conversation with Malika Rembert. As I stated before, obviously Ms. Rembert, we know, is around. We have evidence by way of more little humans and from these two parents. So this petition will not move forward. I will be dismissing it. But what I would encourage Mr. Johnson is that in the event you are in contact with Ms. Rembert, that you encourage her to undertake some of the services that were set up for her at the last juncture, so that if your family is pulled into a CPS case in the future, she can show that she has made some progress. If you feel that she is competent to be around your children, then we would hope that you would feel comfortable enough to encourage her to undertake those services with her own chosen service providers. And that would benefit you and your family and your children, which is really what the goal of the court is in the future, is just to have safe parents and parents that are able to take care of their children. And in order to do that, you have to take care of yourself first, and that includes Ms. Malika Rembert as well. So it will be the order of the court that the petition is dismissed. Mr. Johnson is warned that exposure to Ms. Rembert in the event she has not undertaken services to remedy some of the risky behaviors that we've seen from her in the past will inevitably cause further confrontation by CPS in the name of looking to keep the children safe. But as of today, we do not have enough evidence to say that Ms. Rembert is actively a present and imminent danger to the children. And Mr. Johnson has been investigated. The children are placed with him, and that has been deemed safe. So for those reasons, the petition will be dismissed.
The hearing concludes with dismissal of the petition. After reviewing the evidence, the court finds insufficient grounds to continue intervention. The children remain safely placed with their father, bringing months of uncertainty to a close while leaving future responsibilities squarely with the parents.